Welcome to Medmarc's webinar series. Today's presentation is titled, Don't Think You're a Manufacturer, You Might Be an Apparent Manufacturer, a look at the Apparent Manufacturer Doctrine. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Chris Carton and Jasmine Owens, thank you for joining us. Christopher Carton is a managing partner in Bowman and Brooke's New Brunswick office. He has a national trial practice with deep roots in New Jersey. After graduating from Seton Hall School of Law, Chris, a third-generation New Jersey lawyer, served as law clerk to New Jersey Supreme Court Justice Daniel O'Hearn in the final year of the court under legendary Chief Justice Robert Willans. For more than 20 years, companies have turned to Chris in New Jersey with pressing litigation matters of often unusual complexity in the areas of product liability, catastrophic personal injury, and commercial litigation. Along the way, Chris became a member of the New York Bar and expanded his practice and office into New York, where he now appears regularly in state and federal courts, representing pharmaceutical, medical device, cosmetic, aviation, consumer, and industrial product manufacturers. Jasmine Owens is an associate in Bowman and Brooke's Detroit office. Jasmine advises clients in automotive product liability cases and class actions. She has experience advising major auto manufacturers on discovery and pretrial matters for automotive warranty and lemon law cases. Jasmine managed a portfolio of cases, including document review, document production, motions practice, and advising local counsel on strategy. Additionally, she has served as a public defender representing clients in pretrial hearings in a domestic violence courtroom and served as a research attorney at the Michigan Court of Appeals, preparing research reports and proposed opinions for cases before the court. While in law school, Jasmine served as a judicial intern to the Honorable Marianne O. Batani of the United States District Court for the Eastern District of Michigan. She also served as a judicial extern to the Honorable Robert P. Young Jr. of the Michigan Supreme Court. And with that, I am pleased to turn things over to Chris.
Hi, thank you, Kate, and good afternoon, everybody. I'm here today with Jasmine to discuss the Apparent Manufacturer Doctrine. This is a doctrine that's been around for many decades, although many of us might not have run into it very often in practice, but nevertheless, it's still out there and it's floating around in just about all 50 states in some capacity or another. So we obviously can't cover the entire landscape of all venues and jurisdictions that it might arise and in all contexts. But we hope today to at least provide a general background and understanding of the doctrine, which we think will allow anybody, whether it's attorneys or maybe even manufacturers or distributors or retailers who might be engaged in the chain of distribution of products, to at least understand the parameters of the doctrine generally so that they can guide themselves or clients, as the case may be, in regard of labeling, packaging, things like that related to products to either avoid the doctrine or potentially even use it to their advantage. So to frame the issues and to begin the discussion, we're just going to play a clip from a movie that's all too familiar from anybody, maybe of my vintage. Jasmine, of course, had to ask about it. I don't think had seen it, but in any event, we're going to play the famous guaranteed scene from the Tommy Boy movie with Chris Farley. And we will discuss why we did that after we review the clip. Okay, so in colorful language and description there, we've got a pretty actually deep discussion from different perspectives of the relationship between sellers of products and consumers and buyers of products. So I wanted to address that on both levels in which we saw in the clip. On the first level would be the manager, the generic gentleman with the manager tag on, who Tommy refers to as Ted. So Ted's comment, obviously he's got a customer selling brake pads, and his existing customer, who Tommy is trying to supplant and sell his own Callahan brake pads, his existing customer packages its brake pads with a guarantee on the box. And apparently Callahan's does not do that in practice. What the manager, Ted, says in explanation of that to Tommy is that the guarantee should always be on the box, comforting you being the customer, his customers. And then he goes on to say, my customers need to see that little label looking them right in the eye. So from the manager's perspective here, he recognizes that consumers are induced, comforted by label claims. They will buy products whose label claims provide that comfort. And if you notice, he doesn't necessarily discuss whether the product is quality or that label claim is true. His emphasis is on the customers just needing to see it. Now, turning to Tommy's comments in return, he takes a more cynical view, or maybe goes a little deeper on the issue by asking the question, why would somebody put a guarantee on a box? And Tommy goes further to say that a guy puts a fancy guarantee on a box because he wants you to feel all warm and toasty inside. So they're on the same page there about the consumer's feelings and expectations from label claims, but Tommy takes it a little farther and recognizes the implications potentially of the claims, and that is specifically that it might be a false comfort. The label claims might provide a false sense of security, and in fact, the product inside might be not what it purports to be, or therefore the claims themselves might be false or misleading in some way. So, why did we play that clip in the context of the Apparent Manufacturing Doctrine? It's not necessarily about warranties or guarantees, but we did so because this doctrine, which Jasmine is going to take you through the history of, which was developed in early common law in the very beginning of the 20th century, is based and founded and premised on the sort of implications of the discussion between Ted and Tommy in that scene. That is to say, the concepts of consumer reactions to label claims. So let's start with what is the Apparent Manufacturing Doctrine, and we'll refer to it as AMD today, or fully by the Apparent Manufacturing Doctrine. Generally speaking, it could be described as when a non-manufacturing entity, for example, a retailer or a distributor, can be held liable as a manufacturer of a product if it holds itself out as the manufacturer, such as through its labeling or advertising. So that is to say, where the law provides a certain set of rules that apply to manufacturers, and perhaps different ones for non-manufacturers, people that just merely sell, distribute, but are not engaged in manufacturing. The law, upon the application of the Apparent Manufacturing Doctrine, will apply the set of standards and law that actually applies to manufacturers to non-manufacturing entities in certain circumstances, which we will cover generally. Now, why would they do that? What is the rationale? Going back to the Tommy Boy clip, two reasons generally upon which the doctrine is founded, and they are estoppel and fairness. Estoppel specifically, basically, the foundation is that if somebody holds themselves out as a manufacturer through labeling and advertising, they should be estopped from contending otherwise if a customer relies on it. So specifically in the slide here, a non-manufacturing retailer caused a consumer to believe through its labeling or advertising that it was the manufacturer of the product. And when the consumer relied on the retailer's reputation in purchasing the product, as quoted by a case that we'll talk about a little bit more later, Chevron, and the court stated it as follows: where the vendor puts only its name on the product without indicating that it is actually the product of another, then the public is induced by its reasonable belief that it is the product of the vendor to rely upon the skill of the vendor and not upon the skill of any other. Now, in that circumstances, the courts hold that if you in fact are purporting or suggesting to consumers you manufactured a product, you should be stopped from claiming otherwise if the consumers reasonably relied upon your suggestion. Second foundation of the doctrine, and the case law is fairness, similar to, for example, strict liability and the rationale of why we might impose it on people that even performed full duties in regard of products and might still be liable. It's basic fairness comparing the consumers at issue versus the product manufacturers, in this case, non-manufacturing entities. And as stated by a different court, Hebel versus Sherman, in the case of Hebel versus Sherman, when a retailer, quote, puts out a product as its own, the purchaser, the consumer, has no means of ascertaining the identity of the true manufacturer. And it is thus fair to impose liability on the party whose actions effectively conceal the true manufacturer's identity. Now, there's some general parameters of the doctrine, and we'll just discuss a case I mentioned ago, Chevron versus Aker Maritime Inc., in a little bit of detail, as just a very general administration and application of the doctrine in a real world context. In this case, the Chevron company built at the bottom of the sea, many thousands of feet down, risers that were actually attached to the seafloor. And part of the construction of those risers involved bolts that were going to be bolting this riser to the seafloor. The bolts in the case were packaged by a company called Lone Star, and they came in Lone Star boxes, and they did not identify anybody else on the box as having manufactured those bolts. In addition to the actual boxes that the bolts arrived in, there was a packing slip inside of the box that read, quote, fasteners shipped in this sales order have been manufactured or distributed by LSS Lone Star Houston in accordance with our documented quality system. So if we just take those two elements, the box itself here and the packaging insert, the box has Lone Star's name on it. It doesn't have anybody else's name on it, and it doesn't say it was manufactured by anybody other than Lone Star. The packaging slip inside sort of skirts the issue by saying it's been manufactured or distributed, so suggesting it might be manufactured or it might not be by Lone Star, but again, not identifying anybody else. Now, the bolts in question on their heads did contain small markings of initials, OF, which was Oriental Fastenings, which was actually an overseas party that actually manufactured the bolts. So there was some suggestion that maybe these two letters might mean something. They didn't say Lone Star. And in fact, OF did identify, if you knew enough, the actual party who did manufacture those bolts. Now, so the courts has those issues before it, and the question is whether Lone Star could be an apparent manufacturer. Lastly, I'll note at the last bullet on the slide here, the Fifth Circuit, who ultimately decided the case, noted that in addition to sort of Lone Star holding itself out as the manufacturer, there was evidence in the case that in the industry at issue, this maritime industry that we're talking about, not people off the street who buy these bolts, but the people that actually build these types of risers, those type of consumers, meaning Chevron, would be under the impression that Lone Star manufactured its own bolts. So that was also further evidence suggesting people thought Lone Star made these bolts. Of course, at the end of the day, it was determined that the bolts contained defects, that they were in fact not heat treated and not torsion resistant in the way they were supposed to be. So this is what we might term as a latent defect. It wouldn't be obviously visible to somebody just upon looking at the bolts. But as we know under strict liability, it wouldn't matter if you're found to be a manufacturer and you sell bolts that have that type of defect, you're going to be liable regardless of whether you should have known of it or not. And the court in Chevron found that Lone Star in that case was an apparent manufacturer and would be subject to strict liability. Now, so having gone through just that general case and a general context of which we might see the doctrine, it might raise the sort of, or it might suggest to us the implications of the doctrine and why people fight about it and why product retailers, distributors want to stay out of being called an apparent manufacturer, and why plaintiffs might want to try so hard to put them into the category. And it all, of course, comes down to issues of if you were to consider, say, in the Chevron case, of strict liability principles applying and Lone Star being liable, whether it was aware of those defects or not as a manufacturer, versus, say, common law negligence, where Chevron would have to prove that foreseeability specifically. That is to say that Lone Star, under general negligence principles, would have to be shown to have had some basis in fact to suspect that the bolts were not heat treated, were not torsion resistant, and it would be very difficult to prove. So not every state's products liability laws include strict liability for everyone in the chain of distribution. And so if one can come out of product liability acts or the strict liability context, the plaintiff might have much more challenging burdens, and a company is going to have lots less defensive potentially where it is an apparent manufacturer. So the words from the court, by the way, about the defect in Chevron were, quote, as follows: not only were the bolts the wrong kind, they were also defective due to defective manufacturing process, including failure to stress relieve the bolts and to heat treat them. So as noted, it would be much more difficult for the plaintiff Chevron to prove that Lone Star was aware of the bolts being heat treated unless they were subject to strict liability. Now, again, while we're at the in the preliminary discussion of the doctrine, we just want to remark about some of the products. And again, this is not an exhaustive list. In fact, an exhaustive list would go on for probably many more pages because this doctrine has been around for a long time. But basically, for purposes here today, it should be understood that any product with a defect that is packaged, marketed, advertises, or even just sold, which if it fails can cause damage to persons or to property other than the product itself. In other words, that could give rise to a product liability claim, can be a product that would implicate the apparent manufacturing doctrine. We've listed examples here, everything from bike pedals, bungee cords, lighters, refrigerators, food and beverages, soda. There's also generic medicines on here that we'll talk about a little bit later. So in other words, the pharmaceutical context, hyperbaric chamber, that's in fact a medical device. So the doctrine spans and has spanned across consumer products, industrial products like the bolt we just talked about, into in fact medical products and pharmaceutical products. So it is expansive. And the implications of the products that could be subject to the doctrine are large. Okay, so with that introduction having been put out for you, I want to turn over to Jasmine just to go back to the history of the doctrine, where it comes from, and bring us up to where we are today.
Okay, thank you, Chris. Now let's take a look at the history of the Apparent Manufacturer Doctrine. So this doctrine, which originated in the early 20th century, predates the strict product liability doctrine. So during this time, non-manufacturing sellers were not generally subject to liability for the defective products that they sold. So courts first applied this doctrine to retailers and distributors who placed their labels on products that they had manufactured by someone else. Now, here is an early judicial decision involving the doctrine, Wilson versus Faxon, Williams and Faxon. So the defendant in this case was a medicine retailer, and the retailer purchased proprietary medicine from a manufacturer. So they did not manufacture the medicine, but they did put a label on the product, and that label indicated that they did manufacture the product. Subsequently, a consumer purchased the medicine sold by the defendant and became ill. The retailer sought to shield itself from liability by using an exception in the public health law that a medicine retailer shall be held liable for the quality of the drugs he sells, except for those in original packaging and those that are proprietary medicines. However, the court questioned, should the retailer be given the benefit of this exception available to drug retailers when the retailer held itself out to the purchaser as an actual manufacturer of the medicine? Ultimately, the New York Court of Appeals stated that when the defendant represented to the plaintiff by means of the statements on the label on the box that it was the manufacturer, it rendered itself liable to the purchaser just as if it was the actual manufacturer. The court reasoned that the defendant, by reason of this representation on the label, became responsible to the plaintiff for the strength and quality of the preparation of the medicine, notwithstanding its proprietary character. So as a result, this doctrine, it emerged as a means to impose a manufacturer's liability on certain non-manufacturing sellers who hold themselves out to the public as a manufacturer, but otherwise would be subject to more lenient liability rules than the actual manufacturer. This doctrine, the Apparent Manufacturing Doctrine, is reflected in the Restatement of Torts. We see it first outlined in 1934 in the first restatement in Section 400. Section 400 specifically provides one who puts out as his own product a chattel manufactured by another is subject to the same liability as though he were its manufacturer. Comment C to Section 400 explained the rationale that, quote, by putting a chattel out as his own product, a seller causes it to be used in reliance upon his care in making it and is therefore liable as an apparent manufacturer. About 30 years later, we have the second restatement of torts. In the second restatement, Section 400 was nearly identical to that in the first restatement. However, the second restatement did include comment D to Section 400. And this comment clarified the application of the doctrine and also focused on the aspect of reliance. So, quote, is stated where it is clear that the actor's only connection with the chattel is that of a distributor of it. For example, as a wholesale or retail seller, he does not put it out as his own product, and the rule stated in this section is inapplicable. Thus, one puts out a chattel as his own product when he puts it out under his name or affix it to it his trade name or trademark. When such identification is referred to on the label as an indication of the quality or wholesomeness of the chattel, there is an added emphasis that the user can rely upon the reputation of the person so identified. So here I just want to note that we see the restatement mentioning trademark. Generally for our presentation, we are talking about those within the chain of distribution, but I just wanted to note that the doctrine does also extend to those outside of the chain. All right, so the second restatement, in addition to the Section 400, it also included Section 402A. And this is where we see the section extending the liability of sellers by including strict liability. So now we have the restatement recognizing strict liability. Specifically, Section 402A provides in relevant part, one who sells any product in a defective condition unreasonably dangerous to the user or consumer or to his property is subject to liability even when the seller has exercised all possible care in the preparation and sale of his product. So as I stated, we see the restatement incorporating strict liability. And now Chris will discuss the third restatement.
Thanks, Jasmine. Yeah, so now we've got in mid-century, we have the doctrine of strict liability in place. And so in the restatement of third in the comments, much later, 1998 time period, actually questioned whether the apparent manufacturing doctrine, quote, remained relevant in the context of product liability. And specifically in the restatement of third in the comments, the following was included, quote, after inclusion of 402A in the restatement, that is strict liability, second, imposing strict liability on all commercial sellers of defective products for harm caused by defective products, it was questionable whether section 400 remained relevant in the context of product liability. Once section 402A imposed strict liability on all product sellers, it made little, if any, difference whether the seller of a defective product was a retailer or a manufacturer. Now, so we had a time period where, in fact, it was not clear to everyone, and you can, if you search the literature, find law reviews and things like that, suggesting that perhaps that this doctrine had run its course and was no longer going to have relevance in the product liability world. However, as we can see, moving forward from that time, what happened after the restatement? Most states didn't simply adopt the restatement in all respects. And what we see if we go and canvass the 50 states is that they've all done something in regard of strict liability, either addressed it and refused it or applied it in some context, perhaps through common law or through statutes, but all 50 have not uniformly acted in all respects. And so what we have is a situation where through states sort of break down into different, different places in the law after the doctrine. And that is somehow just have common law now only and don't have a product liability act. Some have adopted their own product liability act. And most of these still have overhanging common law cases discussing the apparent manufacturing doctrine. And so you really need to see what your jurisdiction is and where you fall. And we'll talk about that later on a sort of a tips for managing to see where this doctrine might be implicated. Now, starting with the extreme, just by way of example, we'll start with the extreme, which is Iowa. And as we say on this slide, some states have adopted product liability statutes that actually prevent the doctrine of the apparent manufacturing doctrine by defining a manufacturer specifically as an entity that designs and manufacture a product. So, for example, Iowa immunizes those who wholesales, retails, distributes, or otherwise sells of products from various claims under certain circumstances. The key word there, immunizes. So turning to Iowa Code Section 613.18, it's specifically a limitation on products liability of non-manufacturers. This is engrafted into their Product Liability Act. And it says a person who is not the assembler, designer, or manufacturer, and who wholesales, retails, distributes, or otherwise sells a product is immune from any suit based on strict liability in tort or breach of implied warranty of merchantability, which arises solely from an alleged defect in the original design or manufacture of the product. So as we can see, the limitation there, it's an immunity, and it's written into the definition of a manufacturer, and it's going to immunize anybody who didn't specifically engage in the manufacturing process. So the statute does not create an exception for non-manufacturing sellers that hold themselves out, no matter what they put on their labels. And there are other states that have included, similarly such exceptions. By way of an example of that application of that statute in Iowa, we cite the Murfeld versus Dometic Corp. 2018, in which the court found that, quote, the apparent manufacturer doctrine does not create an exception to section 613.18 and is not viable under Iowa law. As a matter of law, Dometic in this case, a non-manufacturing entity, was not a, quote, manufacturer of the refrigerator for purposes of the statute. Now, in these states like Iowa that have rejected the doctrine, it is because, as we just saw, usually the rationale is it conflicts with the state's product liability statutes, the actual plain language of the words themselves, as we saw from the Iowa statute. So there are states in which statutorily the doctrine is going to be protected against. It's not going to be applied. That being said, though, and conversely, there are states in which the doctrine has taken the opposite tact, and in fact included, if we can advance the slide, have specifically included in their statutes the apparent manufacturing doctrine in their definition of manufacturer. By way of example only, non-exclusive full list: Idaho, Kansas, Washington, Louisiana, all in some form or another account for the doctrine. Louisiana's Product Liability Act's definition of manufacturer is not limited for those who actually manufacture a product, and in fact says that one who quote, labels a product as his own, or who otherwise holds himself out to be the manufacturer of the product, is also considered to be the manufacturer of the product. So there are product liability acts in states that have them. We must look at the actual definitions of manufacturer, and we must determine whether or not, like Iowa, they are specifically excluded non-manufacturing entities, or whether, for example, Louisiana's Product Liability Act, they are included by the definitional terms at issue. Now, when they are included, what we see is they might also include the standard, that is to say the test that we're going to employ in order to bring somebody into the doctrine and make them an apparent manufacturer. Generally, 3 tests have developed, and Jasmine is going to discuss those 3 tests that are generally applied.
In the states that apply the apparent manufacturer doctrine, the courts generally employ 3 main tests to determine whether an entity is an apparent manufacturer: the objective reliance test, the actual reliance test, and enterprise liability test. The first test is the objective reliance test, and this is the test that is adopted by a majority of the states, and it's also the test that was used in the appellate decisions in the early cases, either expressly or impliedly. So the objective reliance test looks at whether a reasonable consumer would have believed that the entity manufactured the product based on the product's label or advertising, and relied on the entity's reputation in purchasing the product. Now let's take a look at some cases that apply this test. First, we have Belinkie, and in this case, the U.S. District Court for the Eastern District of Virginia found that the non-manufacturer was the apparent manufacturer. This case involved a tractor that was manufactured by another entity. However, the court found that Ryobi was the apparent manufacturer based on its involvement with the product. So the court looked at a couple different factors. So first, the tractor itself had Ryobi's name on it. The owner's manual was also printed with Ryobi's name, and even the sales receipt specified that the buyer bought a Ryobi tractor. So therefore, based on those factors, the court found that a reasonable consumer would conclude that it was a Ryobi tractor. On the other hand, in Martin, the Court of Appeals of Louisiana found that the non-manufacturing entity was not an apparent manufacturer. So this case involved a wholesale seller of disposable lighters, and they were not considered they were not an apparent manufacturer because the seller did not hold itself out as the manufacturer to a reasonable consumer. So the lighters involved in the case had the name of the actual manufacturers and not the sellers. So the seller was therefore not liable to the buyer for the defective product. The second test that is used in apparent manufacturing doctrine cases is the actual reliance test. While the previous test looks at reasonable expectations of ordinary consumer, this test takes reliance a step further. Under this test, not only must the consumer reasonably rely on the entity's reputation or assurances, the consumers must also show that they actually rely. This test, however, is not widely used. The final test we have is the enterprise liability test. This test is mainly used in trademark licensor cases, and this test looks at whether the non-manufacturing entity substantially participated in the design, manufacture, or distribution of the product. For this test, the key is substantial participation. Unlike the other tests, there's no proof of reliance on the labeling or advertising. So in the context of trademarks, if there is no substantial participation, the licensor cannot be held liable. So overall, these tests are important because the entity can be held liable under one test and not the other. So it's important to know which test is used in your jurisdiction because that will control the outcome of your case.
Just since we're talking about case law, we wanted to point out also some other recent case law in which the doctrine has applied in different contexts besides, say, lighters, tractors, those sort of consumer products. In this case that's on the screen now, Sparks versus Oxy Health, in fact, the product at issue was a medical device. Specifically, it was a bariatric chamber. It was called the Viteris 320. And the issue in the case was whether or not the distributor of that hyperbaric chamber could be an apparent manufacturer subject to strict liability, even though they didn't themselves actually make the chamber. And in the analysis conducted by the court, the court noted that the defendant distributed the chamber in boxes that it labeled as its own. So in other words, they had their name on it. They did not have the name of the entity that actually manufactured the chambers. Inside the box, the chamber was packaged with a operating and reference manual that was rife with examples sort of insinuating that the distributor was the chamber's manufacturer. Now, importantly, sort of in our modern context here, the court also looked at defendant had made a number of statements in videos that it had provided on its website that it found may lead a reasonable people to believe that the defendant had hand selected the materials from which the chamber was made. So unlike most of our early cases in where we're looking at the actual packaging on a product and the labels, and at best maybe materials that are included with it, in the modern age in which we can have social media posts, we have websites, right? We can make statements about products in other contexts. And here that's what the court did. It actually looked to the website of the distributor and it saw videos that it had posted about these hyperbaric chambers. And it had found that based on statements made in those videos, the suggestion was a reasonable person would be led to believe that in fact, the distributor manufactured the statement. So the court incorporated those representations, put it into its objective reliance test analysis to conclude that that was enough to make the average consumer expect in that space, specifically the medical device space, to think that the distributor actually manufactured or at least hand selected parts very carefully and was involved. To that extent, it was sort of, as Jasmine mentioned a minute ago, it was almost an enterprise liability test partially, in that meaning instead of just looking at whether a reasonable person would consider that to be made by the distributor, the court actually looked at representations made by the distributor that they had been substantially involved in the manufacturing process and had selected materials. So based on all the evidence, the court found that there was a genuine issue of material fact about whether that distributor was the chamber's apparent manufacturer. And it said, quote, in light of defendant's marketing, as discussed above, a reasonable juror could conclude that defendant was the chamber's apparent manufacturer. Another case recently that we just mentioned, again, this is a different application of the doctrine, but we mention it because, number one, it's very recent. This was something that I ran into only in the last year in an actual case. It was also in the pharmaceutical context, so very different than lighters and things and products that we might typically see. And it was an extremely aggressive application of the doctrine, or at least a request. And the context in which this came up was the heartburn medication Zantac. It was a Zantac litigation. And there is the branded form of Zantac made by branded manufacturers that actually have the FDA approval, that hold the NDAs. And then, as many know in the space, you have generic versions of drugs in which generic manufacturers are required to follow the exact formulation of the original branded product, and all warnings have to be followed exactly as well. So generic manufacturers don't have an ability to affect the components or the manufacturer of a branded drug that they release a generic of. They have to follow the formula, so they really aren't implicated and shouldn't be into design defect claims, things like that. And their warnings also are prescripted. They must do the exact ones. So often in the cases of generics, we see preemption filings under the Mensing case on our Supreme Court, in which basically held that generic manufacturers of products likely have, and often do have, a preemption defense to claims such as design defect or warning, failure to warn, because they argue, well, we had to follow the design and we had to use the warnings of the brand. So with that sort of background, Walgreens sold on its shelves a generic version of Zantac heartburn medication that they branded as Walzan. So they had their name on the label and they put it on their shelves, and it was a generic version of Zantac. When Walgreens was sued for the personal injuries, that are alleged to arise in the Zantac context of Zantac litigation, they moved for preemption, and they moved under the usual sort of generic arguments, and that also retailers can argue as well, which is that they were selling a generic version of the drug, and so preemption should apply. And in a very unusual and aggressive use of this doctrine, the plaintiffs in that case actually attempted to use the Apparent Manufacturer Doctrine to say that Walgreens should be considered effectively a brand manufacturer, even though it was just simply selling a generic. And the plaintiffs, to make that argument in that case, pointed to labeling claims on the Walzan product that suggested that Walgreens went beyond doing the things a generic. In other words, they had suggested, quote, that being Walgreens seeks to make its store brand over-the-counter products slightly better than the national brand by tinkering with the product format, and that it implements its own higher standards that are stricter than some regulatory bodies. Now, again, that was not a court language I was quoting, that was plaintiff's language. So not to say this was accepted by a court, and for other reasons, and in the litigation, this motion was not decided, and the court did not decide one way or the other if in fact they were an apparent manufacturer. But we include it because it was an extremely recent and aggressive use of the doctrine to say, that question earlier we addressed of whether it was going to have any relevance at all after the adoption of 402A and strict liability way back when in mid-century, obviously has proven to be not the case. It's still very alive. It's still, we still see it and run into it routinely in different contexts. Now, we'd like to turn some tips for sort of managing risks of whatever your business might be or your profession. And we divide those sort of into pre-litigation and litigation, if unfortunately you might find yourself being accused of being an apparent manufacturer. Pre-litigation tips. Retailers, distributors must be aware of the doctrine, obviously, and mitigate their risk of being held liable for products that they do not manufacture. And the general ways in which they can do that before finding themselves in litigation are through contractually, through labeling, and advertising. Contractually, obviously, if you're going to make sell a product that you did not manufacture, and in fact, somebody else did overseas or otherwise, we always want to consider the contractual indemnification, insurance, things like that. If you're going to go out there and put yourself on a label and identify yourself in promotional videos or whatever it might be, strongly encourage as a practice tip to seek indemnity, obtain insurance and things for protections in case the actual manufacturer, if you're alleged to be an actual manufacturer. Labeling. Retailers can attempt to use fine print to shield from liability. For an example, the label might say manufactured by X for Y, Y being the non-manufacturing entity. But that there is caution there. There have been attempts, as one would imagine, in labeling in all kinds of ways to sort of shield from this doctrine. In the matter of Sandlin versus Bell Sports, we're talking about pedals in this instance. It's a recent case. The question came up of whether the claim of made in China would shield somebody from the doctrine. And the court actually there said it did not, and automatically it creates an issue, stating it that way of whether the product was manufactured in China by somebody else or was manufactured in China for the distributor. So it doesn't answer in express terms the question of who manufactured the product. It might have been manufactured by Bell Sports, but in China. So it wasn't enough to fully put the issue aside. As far as fine print, the Chevron case we mentioned earlier about the bolts, the only fine print that the court sort of remarked there and discussed that might avoid the doctrine is an express statement that someone else manufactured the product. So the court in Chevron referred to the cases of Rutherford and Peterson, which were the Southern Second cases, where there were explicit statements that someone else, not the distributor, manufactured the product. So as we noted earlier, simply initials weren't enough. But in cases in which it's specifically identified as the manufacturer, or even that the party, the distributor, did not manufacture, is going to the best bet. It's never going to be 100% because you're always going to be in this objective test world that Jasmine mentioned, but it's the best possibility of avoiding. Now, tips for managing risk after litigation. Advertising, there was also advertising. Obviously, with respect to advertisements, all the same sort of similar considerations of labeling. Now, tips for managing risk after litigation. What we obviously noted earlier, 50 states come down differently on where they stand if common law versus product liability acts, whether the restatement's been fully or only partially or in any way incorporated. And so you need to look actually in what state you're in, and is it a common law state? And if the answer is yes, is there strict liability under the common law? And if so, does the apparent manufacturing doctrine exist in the common law such that it might provide a cause of action? You obviously then need, as Jasmine recognized, to see what test is going to apply. If there is no common law strict liability, then you need to ask if there's a strict liability or a product liability statute. Most states do have some form of a product liability act. And so one needs to ask, does the statute protect the non-manufacturer seller as a manufacturer? So in other words, do we have an Iowa product liability state that provides immunity and specifically carves out non-manufacturing entities? Or do we have a state like we mentioned, Kansas, Louisiana, by way of examples, in which in fact the court has brought it in through the definition of a manufacturer? So last thing I'd like to mention on the litigation risks and tips for managing after litigation is that, as we'll see in the next slide, after litigation, the apparent manufacturing doctrine can be used defensively, but it can also be used offensively. And what I mean by that is most of the time we're considering it defensively, meaning how do I avoid being an apparent manufacturer? And how do I argue that I'm out of it or that my client is out of it? But we also want to just point out that offensively, the burdens and standards, people want to get out because of all the proof issues in the strict liability world. But there's also the proofs on the plaintiff are much different and more difficult, frankly, in a lot of respects in strict liability, because if you're going to show a defect, you usually have to do so through extensive expert testimony. You have to show that you have a design defect, you might have a warning expert, and also your expert must proffer an alternative design. Those aren't standards that are going to exist under straight negligence, and that might, say, apply outside of being a manufacturer. So in addition to simply thinking of the doctrine as defensively, we also encourage lawyers and companies out there that might find themselves in a situation of it being argued of whether, let's say, discovery is over or getting close to it, and there haven't been expert reports that meet the standards of strict liability. So it should be considered about whether or not people in the chain might actually be manufacturers, and in their certain circumstances might want to be. So we have provided the general overview today, and in conclusion, we just want to remark that the apparent manufacturing doctrine remains relevant in product liability world and the sellers and the retailer distributor world in general. So it's important that anybody who's involved in the sale of products in any capacity that might injure either people or property be aware of the doctrine. So we hope this short summary has been helpful to those in attendance today, and we'd be happy to open the floor for any questions any attendees might have.
Thank you very much. We do have a couple of questions for you. First, are there reasons that a medical practice would have exposure to this liability? And if yes, how should they remediate?
So one thing to be mindful of is when we think of a medical practice, we think of services and we don't really think about the product liability world, right? This is specifically relates to the sale of products. So if the medical practice is simply traditionally, as we think, providing services, this doctrine is not going to be applicable. But if the medical practice, for example, I know I've seen a chiropractor that developed an actual product that he uses in his practice, in his techniques of applying chiropractic medicine. There's a product at issue and you can buy the thing off the shelf. So I would say, Kate, no, normally for services, no, not implicated. It's going to be sales of products. And if the medical practice does involve that, then yes, could be implicated.
Has a court ever applied the apparent manufacturer doctrine against a non-manufacturing entity, even when the label specifically identifies the actual manufacturer?
Yes. So by way of example, again, remember, we're talking about objective reliance and we're talking about fairness. So courts are always going to be performing this balancing test. And if they find that all things considered to the actual sort of consuming the public at issue, and it's not always the general consuming public, it might be a highly specialized consuming public in a certain space, they're going to weigh all the factors. And so there's a case in the Southern Second, it was called Rutherford versus Coca-Cola Bottling Company of Shreveport, 1989 case in which somebody finds a cockroach in their can of Coke and they sue the canner, the local bottling company. In fact, that company, though, had not canned that particular can of Coke. Somebody else had. But the court, in applying that sort of whole analysis of the local community, and in fact said from a point of view of consumers in the bottling company's distribution area, people wouldn't have a question. They would just assume that company bottled it and canned it because they did 90% of most of it. So that is an example of, in fact, even though that can had fine print on it that actually said bottled by somebody else, the court nevertheless found apparent manufacturing doctrine applicable based on all the other sort of objective, factors and the fact that consumers probably thought it was the other bottler.
Do you think you could give an example of a court applying the doctrine based on extremely minimal representations by a retailer or distributor?
Sure. So one example that comes to mind, if you recall, we had a list of various products in one of the slides earlier. One of those products was a bungee cord. And this case was the bungee cord was sold by Ace Hardware. And all Ace did was put the bungee cords on their shelf. They didn't actively apply the labeling, and they didn't advertise this bungee cord, but they advertised the price next to the bungee cord. It said Ace price $2.95. That is an extremely, there were no outward, expressions that Ace manufactured these bungee cords, and they didn't even say on them on the packaging Ace bungee cords or manufactured for Ace. They just said Ace price $2.95. The court let that go to a jury and said that that could very well be enough. A consumer might think, nobody else having been identified, that Ace manufactured that bungee cord. So that's an example of a pretty extreme application of the rule based on very minimal representations.
Thank you. We are just about coming up on the hour, so I think we are about out of time for questions. Chris and Jasmine, thank you both very much for your time today. This is a really, it's a valuable topic for our audience, and I think it's something that might be sort of unfamiliar to a lot of our listeners. So this is really great information.
Thank you.
Thank you for having us.
Thank you for joining us. This concludes today's webinar.